And welcome back to the Dean Obeidallah Show. Right now, as I promised yesterday, joining us today, it's Glenn Kirschner, served as a federal prosecutor for 30 years, also served in the United States Army in the JAG Corps. See him as a legal analyst on NBC and MSNBC. His YouTube channel, Justice Matters with Glenn Kirschner. And now he's got an audio podcast you have to check out, also called Justice Matters. Glenn, thanks for being on.
Hey, happy to be with you, Dean.
So first of all, let me get your overall reaction to, I know small excerpts of the special grand jury in Fulton County that was convened to investigate Donald Trump and others' potential criminality surrounding the 2020 election in Georgia, not federal, specifically Georgia. So what was your overall takeaway from that?
So yeah, small excerpts, but big justice breadcrumbs in that report. Three things in particular that I think are really important and that serve as foreshadowing for where Fani Willis is headed. So I think the first is that the grand jurors said that we set forth for the court our recommendation on indictments and relevant statutes. And then there's page after page of redactions, right? But what they've said there, Dean, is here are the people we believe there's enough evidence to indict, and here are the Georgia state statutes that they violated. And I have to you have to love that Donald Trump said, thank you, Georgia grand jury, complete exoneration, even though all of the names of the people they're recommending be indicted are redacted. I mean, come on, sport. You're not fooling anybody anymore except the most gullible of your gullible base. But that's important because the District Attorney Fani Willis impaneled this grand jury, sought the permission of the court to impanel it, so they could issue subpoenas to reluctant witnesses, and they did that. 75 witnesses gave testimony, including knuckleheads like Rudy Giuliani and Mike Flynn and Lindsey Graham and so many others. Might they be some of the liars? We'll get to the liars in a minute. They might be. And the grand jury did precisely what it was impaneled to do. They came up with recommendations as to who should be indicted and for what. And I'm telling you, Fani Willis is before the regular grand jury right now as we speak, saying, here's the report, here's the evidence, let's get some indictments issued. That's the first important passage. The next important passage is when they say that we have heard from lots of witnesses regarding the nature of the election in Georgia, and we unanimously concluded there was no fraud undermining the results. What does that do, Dean? It puts the lie to Donald Trump's ask of Brad Raffensperger to just give him 11,780 votes. The grand jury has unanimously rejected it and exposed it as a lie, which will be helpful on the criminal intent front. And then maybe my favorite part is that the grand jury also said they decided by a majority vote that one or more people lied to them, and they urged Fani Willis to indict the liars. Here's why that's so important. I put more witnesses before the grand jury than I could ever count. Many of them lied. And if I had the sense that they were going to lie, Dean, and there are three main reasons in my experience witnesses lie before the grand jury. One, they're loyal to the bad guy. They're loyal to the target of the investigation, in this case, Donald Trump, or they're scared of the bad guy, or they're complicit in the crimes that are being investigated. So does that fit the bill for guys like Rudy and Mike Flynn and Lindsey? Maybe. We'll learn more about that in the future. But when I knew witnesses were going to lie because they fell into one of those three categories, I told them the same thing every time before I put them before the grand jury. I said, look, let me promise you one thing. If you lie, I will ask this grand jury to indict you for perjury, if your lie is about a material matter, for obstructing justice, obstructing the grand jury investigation, and for accessory after the fact, because your lies will have the effect of helping the bad guy get away with his crimes. And I'll probably look into you for conspiracy as well. Do we understand one another? Then they would go in, they would either tell the truth sometimes, or they would lie sometimes. When they lied, I had them. Because now I have leverage. Now I can charge them, flip them, develop them as cooperating witnesses, and sponsor their testimony against Trump and others. So listen, what I see in this report that is highly redacted is like a win win, win. And I think the odds have gone up that we're going to see indictments coming out of Fulton County, Georgia, pretty soon.
And so when you read about a majority voted and said that we believe there could have been perjury, they're being sincere and honest, this grand jury. But are you also saying that gives leverage to Fani Willis now, the DA, because there could be people out there who lied and that they can help make the case, say, against Donald Trump if they would speak truthfully, and she can go to them and say, look, the grand jury wants to indict you for perjury, not right now. But if you make a deal with us that we can either not charge you or some lesser offense, something that doesn't destroy their lives type of thing. Is that a potential?
Yeah. So right now the world is Fani Willis's tactical oyster, because she can charge these people for perjury, obstruction, accessory after the fact, and perhaps other crimes if obviously the evidence supports those charges. Or, as you said, she could just negotiate with them. She could say, hey, look, sport, the report's right here. They said you lied and they want me to indict you, but I won't do that. I won't do that if we strike a non-prosecution agreement right now that says I will not indict you for perjury and other crimes if you testify truthfully. I hope she doesn't let people off the hook that easily if they're really bad actors, but she might. That's why I say the world right now is her tactical oyster.
You know, she's described, I was going through yesterday for people, there were articles about who she is as a pit bull in the courtroom. And she tried over 100 jury trials, lead attorney in prosecuting cases. This is what she is. She's a prosecutor. She's not Merrick Garland moderating Federal Society events and hanging out in the hollowed halls and lunchrooms with Ivy League people. You know, she went to Howard University and Emory Law School, and she is a prosecutor. That's what she is. And it gives me confidence. You know, do you, in your view, from what you've seen of the evidence, we talked about this before, but has it changed, especially with this new line, unanimous vote, no widespread fraud, that you believe Fulton County DA, the grand jury, will indict Donald Trump?
Yeah, I think it's inevitable given the nature of this report, given the prosecutor Fani Willis is, and Dean, given the dang evidence of guilt. Donald Trump committed the crime on audio tape. I tried RICO cases where we had wiretap evidence, and I called those press play trials. I pressed play on the old cassette recording machine, and the jurors heard the defendant, who was sitting right across the courtroom from them, saying, all right, I need 6 kilos, I need 4 guns, and I need you to kill this dude. I'm not overstating that. We tried the largest RICO organization in the history of the DC courts. They killed 30 people over the course of 10 years. It was a press play trial. That's what this is. Now, Fani Willis investigated it exhaustively and aggressively, so it has all the window dressing and the bells and whistles, but it's a press play trial, and Trump will be indicted.
You know, I also read that she had brought in a while ago during this investigation, private counsel who was an expert in the state's anti-racketeering law. And that the Georgia state anti-racketeering law is actually broader, the way it's described, than RICO, the federal one. Do you think there's a chance he gets charged with the Georgia state version of RICO?
If she can prove that there was a corrupt enterprise or organization involved. Now, the federal law requires what we call a pattern of racketeering activity, or RAC acts, but the federal code is pretty generous, and it defines pattern as just two unlawful acts that qualify as racketeering acts. I don't know the ins and outs precisely. I never prosecuted in Georgia, but if it's even a more lenient standard, I can look at the organization that Donald Trump assembled to help him try to overturn the results of the presidential election. And it sure looks like it was a criminal enterprise, much as the Trump organization was being run as a criminal enterprise and has been convicted by a New York jury for being involved and for committing tax fraud during a 15-year-long criminal scheme to defraud in the first degree, right? I see the same picture when you look at Donald Trump, Rudy Giuliani, you look at John Eastman, you look at Jeffrey Clark, who he pulled into his conspiracy from the Department of Justice. It looks like, and then you look at Roger Stone and Mike Flynn and Steve Bannon and the rest of them, looks like a criminal organization to me. So it wouldn't shock me if Fani Willis believed she had the evidence to bring a Georgia state racketeering case, and she indicted them all for racketeering.
I'm chatting with Glenn Kirschner, MSNBC legal analyst. Glenn, I heard one attorney on TV, former U.S. attorney, or assistant U.S. attorney, saying if Donald Trump is charged in state court, he could remove this to federal court. Is that true? I know that for lawsuits, but for criminal cases, he can try.
You can try to remove a case from state court to federal court, and then it's a legal battle that has to be fought. You know, they did that not too long ago right here in my backyard when some park police officers were indicted in Fairfax County Court for the excessive force killing of Bijan, who was a motorist who had in low speed fashion pulled away. They overreacted. They engaged in excessive force. It was caught on video. I happen to know that family socially, but and a good friend of mine, Tommy Connolly, is their lawyer. So, you know, I'm kind of plugged in to that case in a number of ways. And they successfully removed it from Fairfax County Court to federal court, and then the federal judge dismissed the indictment against the park police officers. So let's use that as a cautionary tale. It could happen. I don't know that Donald Trump could successfully, I don't think he can successfully remove this from the violations of Georgia state law, assuming that's what he's indicted for, into the federal court. But I would never say never. You know, I think the safety net is that Jack Smith, special counsel, is going 100 miles an hour at this investigation now. And I'm beginning to feel more and more confident that he will indict Donald Trump. So we have a little bit of belt and suspenders going on. We're going to hold up our pants in two ways and make sure Donald Trump is held accountable for his crimes.
I saw which Jack Smith was appointed March 2021 after Merrick Garland was sworn in, or April or May, because as I remind people on the show, weeks before Merrick Garland sworn in, there's Donald Trump speaking at CPAC. He was not leaving. He was engaging more in politics. He was raising money then. Within a few months, he's on the campaign trail doing rallies. And while he's not a formal candidate, Merrick Garland knew what was coming and should have just appointed Jack Smith, the John Wick of special counsels then, and we would have some charges now. But look, so getting that, we learned this week, Mark Meadows has been served with a subpoena. What is the significance of that to you?
Yeah, so it was subpoena palooza this week because Mark Meadows, Vice President Pence, it was Donald Trump's lawyers, all of which are kind of earth-shaking in their own way, especially when you subpoena the target's lawyers. We hopefully talk about that in a minute.
Sure.
But let's start with Mark Meadows. Mark Meadows has criminal culpability for lots and lots and lots of crimes that were committed on and around January 6th. He was like the clearinghouse for treasonous, phone calls and text messages from Ginny Thomas, members of Congress, et cetera. He's burning documents in his fireplace after meeting with Scott Perry, all kinds of lunacy and criminal conduct. I was a little surprised, Dean, that we learned that Mark Meadows has been subpoenaed. Why was I surprised? Well, for a couple of reasons. One, I thought there was a chance Mark Meadows had been cooperating. Mm-hmm. And if the guy's been cooperating, you don't have to, in a very public way, serve him a subpoena, unless you're doing it for cover. Let me tell you, I arrested people covertly, obviously with the authority of a judge who signed a warrant. Gang members, we would quietly take them into the fold, make them cooperators, and then put them back out into the criminal organization, and they would be our eyes and ears. So there were times we did things for cover. It could be that Meadows is cooperating, but they wanted to give him a subpoena as cover to send the signal, look, he's not cooperating, all the while he's out there covertly collecting up incriminating information. That could be, but I don't know if that's what's going on. Here's the other thing. We typically don't subpoena the target of an investigation. And I believe Mark Meadows is one of the targets of the criminal investigation. But serving him a subpoena tends to cut against that. Now, let me tell you, the U.S. Attorney's Manual, which is our procedural Bible by which we operate at the Department of Justice, says you may subpoena the target of an investigation, but it takes all kinds of special approval and dispensation because the target of an investigation has an automatic Fifth Amendment right against self-incrimination because that's the one you're looking to indict. So it's kind of pointless to give them a grand jury subpoena, which is a court order directing you to appear, compelling you to testify, only to have the target walk in and say, I plead the Fifth, can I go now? And the answer is yes, you can, because I can't trump your Fifth Amendment right against self-incrimination unless I want to grant you immunity, because that extinguishes your right against self-incrimination. Then I can force you to testify. I hope to heck they're not going to give him immunity, because he needs to be held accountable for his crimes. He needs to be flipped, and he needs to be a cooperating witness, in my opinion. So I'm not quite sure what we can tease out of the fact that he's been subpoenaed, other than if it's not being used as cover, I suspect he'll walk in and plead the fifth. And Jack Smith will have two decisions to make. Do I have enough to charge him and try to leverage that and flip him? Or do I not have enough to charge him? And if I really want to compel his testimony, I need to give him immunity, which means I may never be able to charge him. That, I hope, is not where Jack Smith lands. I hope he lands on charging him, flipping him against Trump, and using him as a cooperating witness.
So we hear Mike Pence and Mark Meadows they're through their counsel, are going to raise various objections. People hear that. And what we lived through with Trump, with the January 6th committee and during Congress, was delay, and it just becomes too late to do anything. Is this different? And I know that Mark Meadows, Trump lawyers, are going to assert executive privilege, and that'll have to be litigated. I mean, U.S. v. Nixon said there's no cover for executive privilege if you're committing a crime, talking about crime stuff, but still, it's going to be litigated. Mike Pence has this bizarre argument that he's part of the legislature and the debate or speech clause protects him. I'm like, okay, whatever. And I had Jen Taub on earlier as a law professor who said, look, no one's heard of it. And she said, it's novel, but since it's not been litigated, it still has to get litigated at least a little. How quick can this process go, though, when it's a grand jury and a special counsel involved, as opposed to the January 6th committee?
It can go as quickly as the courts allow it to go. The courts can move this thing through the system quickly. I have had a proposal called the Interbranch Dispute Court, the IBDC, where courts have specialized dockets. This can be done by a rule of the court. I know, because I've talked to lots of judges about it. This can be done by a rule of the court. It doesn't take an act of Congress. And all it does is it takes interbranch disputes, or these kind of politically time-sensitive disputes, puts it on an expedited track. So everything is on a 2-week schedule. 2-week briefing schedule, 2-week oral argument, and then you'll get our opinion in 2 weeks. You want to go to the appellate court? 2 weeks, 2 weeks, 2 weeks. We can do it quickly. They did it quickly in Nixon, right? The subpoena for the tapes was issued in April of '74. The Supreme Court unanimously rejected the executive privilege claim in July. 3 to 4 months. Can be done if the courts are willing to do it. Yes, this is a novel claim by Mike Pence that I was a member of the I wish I could do the Mike Pence voice. I don't do impressions. I was a member of the executive branch as vice president. I was also a member of the legislative branch, because I get called in once every 4 years to preside over the ceremonial opening of the envelopes. So I have all of the privileges and immunities members of Congress would have. I don't know if maybe he once got called for jury service, so he's going to claim he was also a member of the judiciary, the judicial branch. Maybe that's coming. This will be rejected, and it will be all but laughed out of court. And here's the other thing, Dean. Even if you want to give that even if you want to give that guy, the jersey's coming out, even if you want to give Mike Pence speech or debate immunity and privileges that he would have if he was a member of Congress, Lindsey Graham had them too. And he was ordered to testify before the Georgia state grand jury. All that means is you have to carve out an exception, and you can't ask Mike Pence about what he was doing in the Capitol on January 6th when Trump's angry mob was looking to hang him. So this, you can skin this cat in lots of ways. Mike Pence will be ordered to testify before the grand jury. And let me finish by saying, I love the sweet irony involved of Mike Pence's book being titled, "So Help Me God," because those are the last words he's going to hear when he's sworn into the grand jury, right before he has to start incriminating Donald Trump.
That's great. And we all hope that happens. And just so people understand as well, and I think they get it, it's common sense, but you're a former prosecutor. If for some reason you can't get what you want from Mike Pence and Mark Meadows, court order, scope of testimony is small, you can still prove the case other ways, right? It's just,
of course,
one level of evidence. It's just one path.
Of course, just like you didn't need those 75 witnesses to testify in that Georgia special grand jury, all you had to do was play that tape. It would not have been as complete a case as it will now be. But, you don't need Mark Meadows or Mike Pence to convict Donald Trump of his crimes, but it would be nice to have them.
Certainly. And chatting with Glenn Kirschner. So, Glenn, another thing with Trump's world, the Trump lawyer, Evan Corcoran, and this has to do with the documents at Mar-a-Lago, DOJ is seeking to pierce the attorney-client privilege. And you know what's interesting? We talked about in the past the case with Judge Carter and John Eastman and how they went through the analysis to pierce the attorney-client privilege there to allow us to see certain emails and criminality. So just first of all, what's your reaction and what does it say in the bigger picture when the Department of Justice says, we want to pierce the attorney-client privilege between Donald Trump and his attorney? What are they telling us?
It says Jack Smith is going 100 miles an hour in the direction of accountability. Because let me tell you, Dean, you know, because you're a lawyer, you practice criminal law, and most people might hear that, oh, well, they subpoenaed some of Donald Trump's lawyers and it wouldn't necessarily register. But in the legal community, it's like a 9.5 on the legal Richter scale. Why? Because when prosecutors are investigating a target like Donald Trump, the last thing we do is subpoena their lawyers to go into the grand jury and provide incriminating information against them because there's an attorney-client privilege. It's not done except when it is done. And when it is done, it's when one of two things are going on. Either the client, Donald Trump, is committing crimes with his lawyer as a co-conspirator and they're both doing it knowingly, or the client is using the lawyer unwittingly to commit crimes on his behalf. Like, hey, and I have full disclosure, I know Evan Corcoran. I've known him for decades. I worked with him at the U.S. Attorney's Office. We had a case in common. I'm sorry to see he has gone this way. He just hired another former colleague of ours, Mike Levy, to be his lawyer. Now that it looks like he's in trouble, it's a small world. But anyway, now where we are at is Evan Corcoran has apparently testified once before the grand jury, as has Donald Trump's other lawyer, Christina Bobb. And the backstory is Evan Corcoran drafted a certification saying, oh, you have all the classified documents now, nothing else here. Christina Bobb signed that certification. And now the question is, okay, who was lying? Was it Donald Trump who was lying and told Evan Corcoran and Christina Bobb, I gave it all over, just don't look in my desk drawers in my office? Or was Evan Corcoran and Christina Bobb, or some combination thereof, complicit in this lie? So it looks like Evan Corcoran went in, invoked the attorney-client privilege, and now Jack Smith and his team are trying to pierce the privilege by saying, no, this was crime fraud going on here. This was Donald Trump and his lawyers, or Donald Trump duping his lawyers into committing the crime of obstructing justice by lying to the grand jury and retaining unlawfully some of these documents that the grand jury subpoena sought. And we have to sort that out. And so I have a feeling if Jack Smith is going after the attorney-client privilege, trying to argue to a judge that it should yield, he's probably got the goods to back it up. And then the next thing you're going to see, Dean, people say, well, what's the next data point that we should be looking for? Evan Corcoran withdrawing from his representation of Donald Trump. That'll be a sure sign that he has been forced to provide incriminating information about Trump. And once you start incriminating your client as a lawyer, you got to get off that representation.
So people should understand the big picture. This is very rare. This is not a unique circumstance. So for the DOJ to say, we want to peer, and attorney-client privilege to lawyers it's just about sacrosanct, because it really goes, it's not just about we have some special privilege with our clients. It's the idea that this whole system that we navigate through, that your client can be honest to you, at least they should be, in telling you all the facts. And then you can develop a case, and it's a criminal case or a civil case, whatever it might be. So this is really, and that's why I wanted to bring it home with you here on this point. This is very significant. This is not normal stuff, folks. And there's no way DOJ asserts this without having some evidence of criminality. They're not throwing this around, right? This is not some, hey, let's try this one, let's see what happens type of thing, right?
Yeah, you just don't give this a fly and let's see if we can, throw the target's lawyer into the grand jury to incriminate him. I don't think I did that in my 30 years as a prosecutor, not once. I mean, we knew it was available, and every once in a while we had to do it. Usually when you had an overtly or an intentionally corrupt lawyer involved, like somebody who knew they were taking dirty money from the client, and we couldn't let that happen, but very, very rare.
Evan Corcoran, he worked with you in the DOJ and the U.S. Attorney's Office. So he's working for Trump. That's fine. There's people, you get your right to a lawyer. I have no problem with that. He drafts a certification that he clearly has qualms about because he won't sign it. And they bring in Christina Bobb, former OAN anchor and Trumpafant, to sign. Literally, they bring her in to sign it. And she even has some qualms because she writes a little note. What is Evan Corcoran thinking? I mean, honestly, as a lawyer, I'd be like, hey, you're putting me, is it that important to work for Donald Trump that Evan Corcoran is on the verge? He had a lawyer up. He's literally lawyered up now. And his career is in jeopardy. His license is in jeopardy. His liberty could be in jeopardy. Was it worth it to draft that thing up? Because clearly he knew it wasn't accurate. I have to be honest. He knew that. That's why he wouldn't sign it.
I can't say what Evan Corcoran was thinking, but Donald Trump basically burns everyone who comes within arm's reach of him. That's true of his, cabinet officials when he was president. It's true of his lawyers who end up being disbarred and potentially prosecuted. As you mentioned, we had a judge fined by a preponderance of the evidence that Trump and his lawyer, John Eastman, committed 2 federal felonies together. These people are going down. Believe me, they're going down eventually. And I don't know what they're thinking. Maybe it's proximity to power. Maybe it's the money, but Trump kind of famously stiffs his lawyers when it comes time to pay them. So it's hard to understand why people would compromise themselves in these ways for Donald Trump. And here's the beauty of it. Once Donald Trump gets indicted, Dean, and he will be indicted, he will throw every single person under the bus, including his own family members, if it will reduce his prison term by just 1 day or 1 hour. So hold on tight, because that's coming.
And very last thing, with Matt Gaetz, DOJ, it's clear they're not going to charge him. I know a lot of people upset on the left about it. I've always been consistent with one thing. Donald Trump should go to jail, not because I hate him, and I do hate him, or not because I disagree with him, because we've seen facts and evidence that support an indictment and a conviction, to be honest. With Matt Gaetz, I saw some reporting. I was waiting for whatever evidence there was. Have you seen anything, and does it concern you, their decision, or from what you saw, was it consistent with that?
Yeah, so I did a long, like a 22.
Glenn, you froze. It's okay because we're pre-taping. Glenn, you froze. Sorry, it's okay. It's pre-tape. We're pre-tape. So
back now?
Yeah, you're back now. So it'll just be, I asked the question, and you just said I did a 22 minutes. So we'll just start with I did a 22 minute.
Yeah, so I did a 22-minute Justice Matters video yesterday explaining my experience as a career prosecutor when I had to decline cases, or I had to make the decision whether to decline cases. And sometimes, I knew that the crime had been committed, but I needed enough admissible evidence to prove the case beyond a reasonable doubt to a jury, and I could never quite get there. And it killed me, but sometimes I just couldn't get there. Here is what I have heard. I've read all the reporting, but I've heard some rumblings behind the scenes. You have 2 really challenging.
They don't want you to tell me this. All right, you're frozen again. You'll be back in a second. They really don't want you to tell me this. Whatever the powers that be are trying to stop you from telling this. So you got to get this out. Now, so you said you said, and again, it's editing, it's no big deal. You said there are 2 really, and that's when I froze. So if you just want to pick it up, right, take 2 and action.
Yeah. So with respect to the decision by the Department of Justice not to bring charges against Matt Gaetz, what I have heard, both in the public reporting and a little bit behind the scenes, though not from any prosecutors at DOJ, I wouldn't listen to them if they wanted to talk to me, and they do not, violate their own ethics and talk about ongoing cases. But there were 2 really important, I would say, critical witnesses in the case. And the Department of Justice, I believe, needed both of these witnesses to be up to the challenge of testifying fully, truthfully, and accurately to the grand jury. One was Joel Greenberg, and he is as ugly a cooperating witness as you can imagine. And there was some talk, not only did he commit horrific crimes, including telling lies to try to frame his political opponents about them being involved with underage girls and them being, prejudiced SOBs and, really ugly crimes. But I also heard some chatter that he kept lying and lying and lying and lying to prosecutors even after he had become a cooperating witness. There is a point in time, Dean, when cooperating witnesses who you try your best to clean up so you can put them on the stand, and you can ask a jury comfortably and confidently to believe and credit what they say, there are sometimes they end up disqualifying themselves, and prosecutors can't use them. I had that happen a number of times. So that's one problem. The other problem is there was chatter that the victim in the case, who I believe was a 17-year-old girl at the time of the offenses, was not interested in cooperating with the prosecution. I can't swear to that, but I have seen that happen in my experience. Some of the victims in these sex trafficking cases don't want to see themselves as victims. And they'll say, listen, I was 17. I was doing everything voluntarily. He was treating me good. He was paying me. He was, so there may be crimes of transporting a minor across state lines for sexual purposes, providing them money, etc. But if the victim of the crime doesn't want to cooperate and refuses to assist the prosecution, then sometimes the case becomes unprosecutable. I feel like those two things in combination, Dean. Listen, I will never pull my punches when it comes to the Department of Justice being too timid or too conservative in their prosecutorial decisions. But sometimes they're making the right call based on the available evidence. And it feels like that's probably what happened. But here's the silver lining. Let's never forget that Matt Gaetz asked for a blanket pardon for all of the crimes he knew he committed on and around January 6th. So I don't think DOJ is done with him, not by a long shot.
We will see, but I appreciate you breaking it down that way, because I think it's really important, because we always want to stay consistent that we don't want to see criminal prosecutions of our political opponents because we disagree with them or dislike them. That's not what the United States of America can be. We cannot allow it to be that. Despite the fact on the right, they cheer, lock him up or lock her up about everyone they don't like. That's not the way it can be. Glenn, thanks so much for spending, and check out Glenn's new podcast, Justice Matters. And of course, his YouTube channel, wildly popular, Justice Matters with Glenn Kirschner. Glenn, have a great weekend. I really appreciate your time and insight as always.
Thanks, Dean.
Take care, my friend.
All right.